Hello and welcome to MediaNama. On November 19, the Delhi High Court heard a copyright infringement lawsuit filed by ANI against OpenAI, the creator of ChatGPT. ANI basically had three complaints. One, that the AI startup used its original news content in an unauthorized manner by storing it and using it to train its large language models like GPT-4, which powers ChatGPT. The suit also alleges that the chatbot is capable of producing ANI's content verbatim in response to user queries. Thirdly, ANI claimed that OpenAI attributed events and statements that never happened to the news agency, which posed a threat to its reputation and it could even lead to the spread of fake news. This case marks the first instance of an Indian news publisher suing an AI company for copyright infringement, something that has played out dozens of times worldwide, especially in the US, which is OpenAI's home country. OpenAI itself has been the subject of over a dozen similar lawsuits in the US itself, filed by various famous authors and news publishers, including the New York Times. It represents an ongoing dispute that has marked the emergence of widely available generative AI applications from the very beginning. AI models are trained on vast swathes of data collected by developers from the internet, often without the knowledge or consent of their creators. This data is often available for everyone to read and access on the internet, like news articles or videos on YouTube. However, creators often consider this to be a copyright violation, as the New York Times claimed that OpenAI and its investor Microsoft sought to free ride on the New York Times' massive investment in its journalism. It accused OpenAI and Microsoft of using the Times' content without payment that to create substitutes for the Times and steal audiences away from it. OpenAI presented an interesting line of defense to this point in the Delhi High Court. Their lawyer basically argued that copyright protects how something is written, not the information itself. It protects the expression, but not ideas or facts. That's like saying that you can't copyright the fact that it rained yesterday, but only the specific way you describe that rain. At the same time, OpenAI seems to be taking a different approach to other news organizations, perhaps as a way to prevent any more copyright lawsuits. It has begun to strike deals with news publishers, offering to have their articles linked and credited in ChatGPT responses. It has already announced partnerships with Time Magazine, Atlantic, and News Corp, which owns publications like the Wall Street Journal and the New York Post. As artificial intelligence continues to evolve, this lawsuit represents a critical moment. The Delhi High Court has already recognized the complexity of the issue by appointing two amici curiae, Advocate Adarsh Ramanujan and Dr. Arul George Skaria from the National Law School of India University, to help navigate the unprecedented legal territory. Moreover, this lawsuit highlights a broader existential question for media organizations. In an era of generative AI, how do news agencies maintain their value and protect the content? This is not just about one news agency against one tech company, but could decide the future of copyright law and the AI industry. Thank you for watching. For more tech policy updates, please subscribe to MediaNama.